extra sure we have time to hear from all the terrific judges that the American Constitution Society has succeeded in putting together on this panel, and also all the panelists have suggested to me, and I agree, that it would be great to have time for questions and to really turn this into a dialogue, because I assume many of those in this room, I know some by face, may know as much, if not more, than all of us do about some of these issues. And so with that, beginning on time and hopefully moving things expeditiously through the topics I want to cover, just a reminder to make sure you're in the right place. This is the panel on the future of federal sentencing. The Supreme Court continues to sort it out. It dawned on me that it might be more accurate to subtitle the panel, "The Supreme Court Continues to Screw Things Up," because to suggest the Supreme Court is successfully sorting things out, it's easier for me to say. I actually tend to view some of this jurisprudence as a Doug Berman Full Employment Act, but for
so do we.
Yes, exactly. For the judges, they actually have to figure this out and can't simply do what I do on my weblog, which is highlight how crazy this is and how many questions are left behind. They actually have to make the decisions. We're fortunate to have two fantastic district judges and two fantastic circuit judges, and I will introduce them very briefly and provide an overview of some sort of the background legally, and you might say emotionally, about these issues, and then leave it to them to both describe not only their professional perspective on these questions, but maybe encourage them to weigh in a little bit more personally about where they've been taken by the Supreme Court and where they think the Supreme Court may take everybody in this arena. We have, and going just down the line, Judge Nancy Gertner, U.S. District Court Judge for the District of Massachusetts; Judge Lynn Edelman, U.S. District Court Judge for the Eastern District of Wisconsin; Judge Theodore McKee, U.S. Court of Appeals for the Third Circuit; and Judge Jeffrey Sutton, U.S. Court of Appeals for the Sixth Circuit. I'm not going to give their full bios, not only because you can read them in the program, but because I'd use up 95% of our time just to scratch the surface on all the terrific work they've done before becoming judges, and particularly exciting and lucky for me is they give me lots of content, directly or indirectly, for the weblog that I do. I'm Doug Berman. I teach at the Ohio State University College of Law, and my claim to fame, I suppose, is I've been running a weblog, Sentencing Law and Policy, that's been trying to keep up with the Supreme Court's gyrations in the field of federal sentencing over the last few years. And that's sort of my intro, in some sense, because I took pride in teaching in the area of sentencing law for the last decade since I became an academic, because it was an area that was extraordinarily dynamic, despite the fact that the Supreme Court, as a constitutional matter, seemed to leave it alone. Many people know, and many people obsess over, the U.S. Supreme Court's death penalty jurisprudence, and it's accurate to say that they continue to try to sort out what the Constitution's prohibition on cruel and unusual punishments means for the application of the death penalty in the states. But I often tended to avoid, in my sentencing classes, talking about the death penalty, not only because it really is a tiny part of modern criminal justice systems, but because there's plenty of other people who are eager to talk about the death penalty in the Supreme Court's jurisprudence over the last, really, 4 decades now almost, about the death penalty. I took pride in talking about what really matters, what's really important, and what the Supreme Court has always ignored, which is non-capital sentencing. The literally millions of other cases that come before state and federal courts every year, in which a trial judge, a sentencing judge, has to decide what sentence is appropriate for a particular offender as a result of a particular offense. And like I said, the Supreme Court largely stayed out of this area. There was a case that I certainly read in law school that kept me busy, but I didn't even understand at the time because I didn't have a sentencing course, Mistretta, in which the Supreme Court signed off on the uniquely dynamic arrangement that Congress created through the Sentencing Reform Act of 1984 to create the U.S. Sentencing Commission, which it technically put in the judicial branch, but arguably is really exercising legislative powers at the same time that it encourages prosecutors to exercise their executive powers. I think it's the way I tend to look at sentencing commissions, is that they really have power and authority to dabble in the work of all three branches, and that was among the arguments that were made against the U.S. Sentencing Commission as created by Congress, and the Mistretta case, 8-1, with notably Justice Scalia dissenting, ultimately approved the constitutionality of the sweeping reforms that Congress put in place through the Sentencing Reform Act. But beyond that, and in some sense that itself is a statement of the Supreme Court's disinclination to constitutionalize modern sentencing reforms, beyond that, the Supreme Court largely stayed out in what's a little discussed but extraordinarily important decision from 1986. Chief Justice Rehnquist wrote an opinion for the court in Macmillan, which highlighted that the court was not going to apply any real significant due process limits on sentencing procedures. In Chief Justice Rehnquist's words at the time, he didn't want to constitutionalize burdens of proof at sentencing, and so that approved the application of a preponderance of the evidence standard for the application of mandatory minimum sentences. Subsequently, in 1997, a case that when I teach it to students, they still say, you must have made this up because this can't be true. In United States versus Watts, the Supreme Court approved of sentence enhancements based on so-called acquitted conduct. That means that even if a defendant has been acquitted of various charges, a sentencing judge can, some might say arguably must, under the federal sentencing guidelines, consider conduct related to the acquittal in deciding what the applicable guideline sentencing range will be. And though this has been established constitutional law now for a decade, I still get questions from reporters, most recently actually after the Conrad Black conviction, because he was acquitted of most of the charges but convicted of a few. I now have to explain to Canadian reporters that yes, in fact, us Americans, notwithstanding our commitment to trial by jury, allow sentencing judges to consider acquitted conduct to enhance sentences. And United States versus Watts, I tend to view as the high watermark of the Supreme Court's assertion, again an opinion by Chief Justice Rehnquist, that constitutional law doesn't have anything to say when legislatures and commissions have decided to run its sentencing systems this way. There may be some due process limits, say the court, but even acquitted conduct doesn't cross the line into unconstitutional procedures. And I was, again, sort of proud to have noticed that case and to talk about that case and to obsess over those sorts of cases. But an aspect of my own scholarship was about how exciting it was that the story of non-capital sentencing reform wasn't a story that obsessed about the Supreme Court, but rather obsessed about what legislatures were doing at both the state and federal level, what sentencing commissions were doing, and then what the real judges were doing, not the Supreme Court justices, but the trial judges and the appellate judges at the state and federal level, to figure out, without really worrying about constitutional norms, what's a sensible sentencing system and how that system should apply going forward. Then along comes, it's a multi-headed revolution. I think the justices themselves would say it started with the Jones decision in 1999, although technically that was a statutory interpretation decision, not a constitutional ruling. But we get Jones in 1999, Apprendi in 2000, the true blockbuster in Blakely in 2004, in which the court essentially explained that Apprendi not only applied to some bizarre state sentencing schemes, but applied to guideline systems. Booker, which was the federal application of Blakely, and so I guess it's properly described as the Jones-Apprendi-Blakely-Booker revolution, which brought the Sixth Amendment to bear in the application of structured sentencing reforms. And I won't give chapter and verse about the jurisprudence of the Sixth Amendment here. The simple story is the court, for a variety of debatable reasons and on a variety of debatable theories, concluded that judicial decisions to enhance sentences based on their own fact-finding is constitutionally problematic when it exposes a defendant to a higher possible sentence than would be permitted based on the jury's determinations or the defendant's plea of guilty. And one of the important nuances that all the judges on this panel understand, that anybody coming to this debate should be attentive to, is 95 out of 100 cases get settled by pleas, not by a jury verdict, or at least those that get sentenced are those percentages. And so when we talk about sentencing having to be respectful of the jury's determinations, we're only talking about 1 out of every 20 cases in which there is a jury determination. In the other 19 cases, it's a plea of guilty that provides the framework and setup for a sentencing determination to follow. And so one of the big debates at a practical level concerning this new Sixth Amendment jurisprudence is, what does that mean for plea bargaining? And that's one of the many topics that I hope our panelists will talk about. Booker was the sort of landmark case for the federal sentencing system in particular, because in a remarkable opinion, I think, and I need a constitutional scholar to make sure I'm right about this, but I think it's probably the only Supreme Court opinion with two majority opinions, neither of which command the majority of each other. Booker had two separate opinions, a constitutional merits side, which had 5 justices declaring the federal sentencing guidelines unconstitutional because it called for judicial fact-finding to raise a defendant's sentencing exposure. But then a different 5 justices, although with Justice Ginsburg being the unifying vote between the two majorities, a different 5 justices said the proper remedy for that was not to require juries to be involved in fact-finding or to have a more robust trial proceeding in the application of the federal sentencing guidelines, but rather to make the entire guideline system advisory rather than mandatory. And so what I teach my students, what I encourage them in thinking about the day-to-day particulars of federal sentencing is not to obsess too much about the Sixth Amendment anymore, because Booker helped make that part of the ruling evaporate by now turning the guidelines into an advisory system. The problem, of course, and the problem that the judges on this panel are particularly engaged with on a day-to-day basis is, what does it mean for the federal sentencing guidelines to be advisory? And there have now been a series of Supreme Court cases, one fully decided, 2 more now being briefed, trying to deal with this post-Booker question, namely, what effect can the guidelines have now that they are no longer mandatory and have to be, as a constitutional matter, advisory to continue to apply in the federal sentencing system. And the decision just this past term was in United States versus Rita, which held that in the application of an advisory guideline system, it was permissible, not required, but permissible for circuit courts to apply a presumption of reasonableness to any sentencing decision by a district court that complied with the guidelines, that fell within the recommended range by the advisory guidelines. And I believe, and they'll correct me if I'm wrong, that we have 2 circuit judges who are in one circuit, the Sixth Circuit, that has adopted a presumption of reasonableness for within guideline sentences, and the Third Circuit, which has rejected a presumption of reasonableness for within guideline sentences. And remarkably, what's that?
On paper.
On paper, true. We'll get to that. What's remarkable is the Rita case the Supreme Court took up was supposedly to resolve this circuit split between those circuits that applied a presumption of reasonableness and those that had rejected it on paper, a presumption of reasonableness. Justice Breyer, writing for shaky 6-justice majority, because there's lots of concurrences, actually it's an 8-justice majority depending on how you count, ultimately said it was permissible but not required for a circuit to adopt a presumption of reasonableness. So amazingly, though conflicting in their approach to post-Booker jurisprudence, both the Sixth Circuit and the Third Circuit were right, congratulations, in figuring out what Booker meant for circuit court jurisprudence. Of course, there's another piece of this equation, another piece that was supposed to be answered this past term. What do we do with sentences that are outside the guideline range? Could there be, although no circuit has said this, a presumption of unreasonableness for when a district court doesn't follow the guidelines? Here's an interesting reality. No circuit had said that they adopted such a presumption of unreasonableness for sentences outside the guidelines. Nevertheless, in fact, that seems to be what most circuits were applying, or at least a sort of de facto expectation that if a district court was going to go outside the guidelines, the judge needed to provide, in fact, this is the jurisprudence, extraordinary justifications for any large variance from the guidelines. And this case, Claiborne, was a case from the Eighth Circuit that was to address not what happens when a district judge decides to sentence within the guidelines, but what happens when a district judge decides to sentence outside the guidelines. The problem, really much more of a problem for Mario Claiborne than for the jurisprudence, was that he died while the case was pending. In fact, only a matter of weeks before the end of the term. And so, indisputably, the court had spent a lot of time thinking through this question and probably had written up a lot of their thoughts about how circuit courts should review district court decisions to sentence outside the guidelines. But they didn't get a chance to articulate that because the Claiborne case had to be dismissed as moot because of Mario Claiborne's untimely demise. Fortunately, there's plenty of federal defendants to go around, and the Supreme Court was able to, even before it released its Rita opinion, to accept cert on 2 cases to replace Mr. Claiborne. I guess Mr. Claiborne's legacy is his case was worthy of 2 follow-ups because the Supreme Court took cert on a case, United States versus Kimbrough out of the Fourth Circuit, which addresses crack sentencing, although there's lots of there that we could talk about, and then United States versus Gall out of the Eighth Circuit, both cases in which a district judge imposed a sentence below the applicable guideline range, but a circuit court, the Fourth and the Eighth Circuits in each case, respectively, reversed that as unreasonable. And I think it's fair to say, in fact, there's reason to believe the Supreme Court sees what the circuits have been doing as applying a de facto presumption of unreasonableness to sentences outside the guideline. And just to provide my own prediction and then to set up our other panelists to begin talking, I think the court is troubled by the instinct that an outside the guideline sentence should be presumed unreasonable. And so they will likely say in these cases that circuits can't apply a presumption of unreasonableness to outside the guideline sentences. The problem, of course, is the circuits say they're not doing that. And so what matters, and Judge McKee in some sense set this up already, is not just what is said on paper in these circuit decisions, but how that gets applied. And one of the things that's been going on as these cases have been litigated is a number of folks, myself included on the blog, have been tracking the quite noticeable patterns in which almost all of the below guideline sentences, when they're appealed by the government, get reversed as unreasonably lenient, but almost all above guideline sentences, when appealed by the defendant, get upheld as not unreasonably harsh, although there's an important outlier that I recommend everybody to read. Just yesterday, shows how timely we all are, Judge Sutton released an opinion, or the Sixth Circuit released an opinion authored by Judge Sutton. The name of the case is United States versus Poynter, and God forbid you phonetically spell. It's Poynter, out of the Sixth Circuit. You can find it on my blog, among other places, where Judge Sutton provides, I think, indisputably what is right now the leading post-Rita analysis of how to make sense of the review of non-guideline sentences. And it involves actually the Sixth Circuit reversing an above-guideline sentence that was extremely harsh relative to the guideline range, and I'll let Judge Sutton speak about that some more. The last point I want to make, and then I will let our panelists take over, is that notwithstanding the Supreme Court's intervention and our ability to talk, myself included, ad nauseum about what this jurisprudence means, none of this has eliminated the significant dynamics of all the other branches involved in the development and application of sentencing law and policy. Whether or not these judges will admit it, many federal judges have been asking themselves, in the classic WWJD world, what would justice do? Not what justice demand, but what would justice do, meaning what would the Department of Justice do if I issue a below-guideline sentence? Will they appeal? Will they run to Congress and ask for a legislative fix to Booker? What will Congress do? There was much discussion after Booker among the judges, some of it public, some of it not so public, about how Congress might react if judges did not continue to follow the guidelines in most cases, and the statistics show they continue to do so. Meanwhile, the Sentencing Commission keeps chugging along, and in fact, just this last amendment cycle has finally, 20 years after they probably should have, significantly reworked, although not as significantly as some would hope, the harsh crack guidelines, which get so much of attention because of the disparate ratio between how the guidelines treat crack offenses and powder cocaine offenses. In addition, just to guarantee that I don't get a 4th of July with any rest, celebrating our nation's commitment to liberty the week of July 4th, President Bush decided to set Scooter Libby free, although that's not quite right. But he did say, in contrast to any circuit that's decided these issues, that a sentence within the guidelines, namely Scooter Libby's 30-month sentence after his perjury and obstruction of justice charges, was, he didn't say unreasonable, he said excessive. He commuted the entirety of Scooter Libby's 30-month within guideline, bottom of the guideline range prison sentence because of his conclusion, as articulated in his statement, that that prison term was excessive for a man like Scooter Libby. And we can talk about what that exactly means, and I mean that to be as pregnant as it sounds. But it highlighted for me, both in terms of my logging and in terms of when we look toward the future of federal sentencing, how many opportunities there are for the other branches, directly and indirectly, to continue to shape where this dialogue is going. And so with that quite lengthy but hopefully helpful overview, I now leave it, I'll give the district judges, because they have to do the real hard work in most of the cases, to articulate their own view of where we've been and where we're going. And again, as I suggested, not only to provide some professional context for how they come to their perspectives, but some personal observations about what all this means going forward.
You're looking at me first?
No, whoever's, you can go alphabetical. You can.
You can let him go first, alphabetical.
Okay.
That way I can react.
All right, Nancy wants, she's a critic. Okay, first of all, I want to thank ACS for inviting me, and before I even say much, I want to put in a good word for Doug Berman's blog. You know, we had, at our recent 7th Circuit meeting, we had a whole panel on bloggers, on legal bloggers, and everybody agreed that Doug's blog was the one that, I guess it's been cited in, what, 20 written opinions or something? So it's really been a
You've
great...
written 15 of them, but I appreciate it. I
And I've the other 5.
Right, exactly.
Well, you know, I have a self-interest. But anyway, it's really contributed to the sort of being able to talk about these issues. Maybe the best way to respond to what Doug said about personal experience, I practiced some criminal defense law before I became a judge and also before the guidelines went into effect, and I really thought that it was a decent system. Now, I understand maybe there were judges in various places that were, you know, imposed excessively harsh sentences based on race or some other improper factor, but that was never my experience. And then when I got on the bench was in '97, and then I had to deal with the mandatory guidelines, which were then mandatory, and I hadn't really ever practiced too much federal criminal law, so they were kind of new to me, and I found them utterly and totally appalling. I thought they were way too harsh, they were tremendously rigid, and they were just essentially unfair. And I tried to depart. You know, you were supposedly able to depart under the old guideline regime for sentences that were outside for situations that were outside the heartland, but that, of course, it was not very clear what that was. But the appellate courts then, as they are now, were very excessively, I don't think maybe that was the idea, that appellate courts should be so police-oriented. I mean, in the sense of seeing their job as the job of policing district judges, but that's essentially what they did. They interpreted the district judge's authority to depart from the guidelines in very narrow ways. So essentially, the district judges were in this kind of cage. It was very hard to, in many cases, I just couldn't impose what I thought was a fair sentence. Now, you know, maybe other people would disagree. And then when Booker came along, Booker made the guidelines advisory, as Doug has said. And, you know, now Nancy has written that you're not supposed to think of Booker as free at last, but that's what it was. That's what it was, for me anyway. I mean, it allowed me to be a judge for the first time since I'd started sentencing people. I mean, I'm exaggerating a little bit, but I mean, because I departed and I did what I could before the Booker. But since Booker, it's been really, in most cases, now you got to leave aside the mandatory minimums, which is a whole nother problem, that on top of the guidelines, there's a lot of mandatory statutory minimums, which you can't do anything about those. But leaving those aside, I would say in most cases now I can impose something pretty close to what I think is a fair sentence. And maybe it's the strangeness of the U.S. Attorney's Office in my district, but and maybe it's the Seventh Circuit hasn't been as bad as some of the other circuits on this. But I've never had a sentence reversed, and I've only had one appealed, and that's sort of pending, and they'll probably hold, they pended it because of Claiborne. It was sort of one of these child porn cases where there's, I mean, it was, I don't want to go into all the facts, but it was a 5-year mandatory minimum. It was a kid who, you know, shouldn't have been looking this stuff, but there was no chance at all, in my view, that he would have ever really hurt anybody. And his guideline was 120 months, and I gave him 70, which was 10 over the statutory mandatory minimum. And that's the only one that's ever been appealed, and that they haven't decided that yet. So for me, I mean, Booker has really made a huge difference, and I think that it's probably can't get worse than it was before. Whatever the Supreme Court does in Gall, and incidentally, we have the district court judge who's the author of the Gall case. Judge Pratt is here with us. So,
Listening carefully.
Right.
and
It looks like you're trying to go incognito, but you called him
well,
out.
no, it's a heroic opinion. Whatever they do, it's probably gonna be okay for me. But maybe my circumstances are unique, because talking to other judges around the country in certain circuits like the 4th and the 8th, and even in my circuit, you know, they write these opinions. Oh, we have a very deferential, light review. You know, this very light review of the district court's decision. But that's always in cases where you don't really do anything. You know, when you get to a case where the judge really does go substantially below the guideline, then you don't see that light review quite as much. It's sort of, you know, so there's a lot of institutional enemies to fair sentencing. Okay, that's really, I think, the real problem. And you know, it's sort of interesting. When I was listening to that panel, the plenary panel, you know, and I was thinking about race and equal protection, and somebody mentioned caste. I mean, what we have in this country is sort of a caste of people who are incarcerated. And you could make a very strong argument that we've really, any gains that we made in the civil rights movement, many of them have been sort of nullified by our incarceration policies in this country. And so, I mean, we really need a lot of serious work, not just legal work, but other kinds of work. But anyway, meanwhile, the enemies of fair sentencing, first of all, I don't think we can ever expect much from Congress. I mean, look, at least we don't have my own fellow Wisconsinite, Jim Sensenbrenner, as chairman of the House Judiciary Committee anymore. And so we're not hearing threats about topless guidelines being reinstituted. But, I mean, I think the best we can hope for from Congress is not to do anything, because they're not going to. Politically, I just don't think they want to do anything really in the way of reform. The Department of Justice, in my view, has essentially defied the Supreme Court, because even though under Booker you're supposed to use the 3553A statutory factors, in every single case the Department of Justice recommends a guideline sentence. Now, you know, why is that not exactly contrary to what the Supreme Court said the law was? But, you know, maybe if Gonzalez, maybe he'll change his tune if they charge him with perjury or something. No, I don't know. All right.
Hope springs eternal.
Yeah,
Right?
anyway. Okay. The Sentencing Commission promulgated these guidelines and has never retreated. And the chairman, Hinojosa, went before Congress and said that the guidelines incorporated all the 3553A factors. That's the statute which has a whole list of factors which now govern sentencing, which was palpably absurd. So you have a Sentencing Commission which maybe has a lot of smart researchers and collects good data, but basically is part of the problem, and I don't ever see them really in their present guise as becoming part of the solution unless they get really changed. You have the Courts of Appeals, which I think, with all due respect to my colleagues here, they still look at their attitude as sort of policing district courts. And it's sort of like, see, here's where I think the guidelines came out of. I think the guidelines and the whole Sentencing Reform Act, which I think was a tragic mistake, really what they came out of is this whole sort of, not in terms of like some of the people that wanted to, for good reasons, to rationalize sentencing, but that wasn't really where the energy was. The energy was all this hostility to judges that built up from the 50s and the 60s and the Warren Court and Miranda. And it was really the whole impulse behind the guidelines was to stop, quote, liberal district judges from exercising discretion. That's the fundamental animating purpose of the guidelines and the Sentencing Reform Act, and that still persists today. And the courts of appeals in many cases share that perspective, and the commission shares it, and many congressmen shares it, and the Department of Justice shares it. And so basically what you've got is district court judges who are the only possible source of fair sentencing in this country. And, you know, most of them haven't ever done anything but sentence within the guidelines. They haven't. And most of them never practiced, many of them have never practiced criminal law, so they don't have a lot of confidence in sort of rejecting guidelines and stuff. So there's a lot of institutional problems to developing fair sentencing, regardless of what the Supreme Court does. So.
But how do you really feel, Judge?
Okay.
Judge Gertner.
I've now written on 17 pieces of paper. I don't know where to begin.
So why don't you have something to respond?
Right. First of all, I'd love to reach a point where we leave this discussion. And in other words, the discussion should no longer be about rules versus discretion, but should be about how we should sentence people. In other words, substantive discussions about the best way to sentence, what you do in cases involving drug addicts, what you do in cases involving downloaders of internet pornography but who have no other record of being a predator, what you do in the case of someone with multiple small offenses that comes to your court all of a sudden, and it's clearly a drug pattern of recidivism. There are a whole host of things to talk about that are substantive discussions that the guidelines stopped because of the premise that the Sentencing Commission had thought of all of that. Well, of course, that wasn't true. The Sentencing Commission had not thought of all of that. The Sentencing Commission had done a lot of thinking, but certainly had not addressed all of these myriad issues about actually what to do in the concrete case. And I agree with Lynn that we have to deal with what we do in the concrete case. What do you do with a real offender in front of you? The problem over the past 20 years is the illusion that the Sentencing Commission has done that thinking for judges when it really wasn't true. And every judge from one end of the country came to doesn't matter, conservative or liberal, had sometimes multiple occasions where you would add up the column of figures and the result made no sense. And the question was, for the past 25 years, what were the machinations that you had to go through in order to say it made no sense? But everyone had this experience. You know, the guy who became a career offender and was at now 15 years based on 2 minor offenses. Well, it technically fit the category career offender, but my God. The 80-year-old who's facing a 20-year term because of the quantity of drugs. A system that was based on drug quantity, which meant that you no longer looked at how the guy lived. Pre-guidelines, you'd say, did he make his living from drugs? Was he driving a Porsche? As opposed to the guy who was just guarding the stash. Well, under the guidelines, the quantities were suddenly going to drive the sentence, and you no longer ask real questions. So I want to get to a point where we can ask real questions about what do we do, about recidivism, about rehabilitation, even in the cases that we can address rehabilitation. And to the extent Booker has opened up that conversation, that is fabulous. Will that continue? Every country in the world is dealing with guidelines virtually now. Because although the question of what to do in a given case is a terribly important one, very few countries have a developed philosophy of what to do, a developed approach. And so it is true that if every one of the hundreds of judges across the country went off implementing their own philosophy of sentencing, we would have differences all across the country. And that's to some degree what has led to the concern about guidelines everywhere. And it gets back to my first point. That's why I want to talk about what we ought to do, not about mandatory artificial rules, but if you gave me studies about what to do in X case or Y case or Z case, that's what a rational sentencing system should involve, not artificial formulas that don't apply to real human beings. Now, as I said, that's a conversation I want to get into. The Commission is not getting into that conversation. There are individual judges who are getting into that conversation. Court of Appeals is not even close. How did that happen? Or at least my Court of Appeals isn't close. Although I have to admit, post-Booker, I've not been appealed either. It is true if you write 97 pages of whatever. Ain't nobody going to touch it. Really, I mean,
That's why academic articles are so long.
I mean, I teach sentencing. I actually see with some of my students. I think that my opinions are more than just whatever, but still, there's no question that that has stopped sentencing appeals. How did we get to this point? I think that I actually think that the animus for the guidelines initially was not bad. It was a concern about leniency. By the way, it was also driven by the women's movement in many of these countries. It was concern about leniency with respect to sex offenders and rape that drove guidelines in many of the states that brought them into play. The problem with the guidelines as they developed is that they have sucked the air out of everything, sucked the air out of the discussion of sentencing. When you came up with something that looked like the answer, a formulaic approach to sentencing, judges who had essentially no training in what substantive rules would look like, what would actually do in particular cases, it was much easier to abide by the formula than it was to do any real thinking. And you couple that with the anti-judge bias, it was much easier to say, the guidelines made me do it, there's nothing I can do, than actually exercise judgment. And the courts of appeals went down this path because, of course, they had never dealt with sentencing before. It should have come as no surprise that courts of appeals that there were never sentencing appeals before the guidelines. So courts of appeals that never addressed sentencing at all should see Gertner on drug recidivism and the guidelines. And it was clear it was going to win. The guidelines were clear, looked like law, were formulas, and if you've never done this before, that looked much more interesting and much more compelling than we know something about drug addiction in this country. We can identify, not perfectly, who will recidivate. We know something about programs, and the guidelines invariably push the discussion in that direction. And there's studies that have been done about the impact of anchoring as well. You put numbers on anything, and suddenly that becomes the framework. When the Supreme Court now suddenly put a constitutional lid on mandatory guidelines, that one way of looking at it is to say, to the extent the guidelines were being enforced as mandatory rules, there were Sixth Amendment problems, and said to the judges, now if they can be advisory in order to escape that constitutional conundrum. The difficulty is that it was very difficult, that judges could not get out of the box in which they had put themselves. There were exceptions across the country, but district court judges, for the most part, the compliance rate, so-called, with the guidelines was still and continues to be in the 80s and 90s, because that was a framework which had really sucked the air out of the discussion completely. And courts of appeals didn't have another way of thinking about the world than a guideline framework, and the Supreme Court could say all they want. Think about it as advisory, but if you have no alternative view, you can think about it as advisory till you're blue in the face, it wouldn't matter. So my hope was that what the Supreme Court would do, not so much in Rita, but in Claiborne, and I hope does in Gall, is to set legal incentives for creativity. In other words, if the Supreme Court says that an outside the guideline sentence is not unreasonable, if the Supreme Court said that we recognize the limitations of the guidelines, and that we encourage thinking outside the guidelines. And we understand that the guidelines, in fact, when they were passed, were a rough cut, and that there were many areas that they had not addressed, and that the Commission never considered the purposes of sentencing in what they did. There are guidelines that are fiat, 2 points roll increase, based on what? What I do have to justify, what they did, they didn't have to justify. If the Supreme Court gave support for non-guideline thinking, then we might be able to see some real creativity. Now, the Gall case is a classic example of that creativity, and if you told people the facts of the case, not judge went outside the guidelines, you told them the facts of the case, I dare say that most of the American public would understand that that was the exact right result. Someone who had been in a drug conspiracy for a finite period of time on his own, not at the constable at the door, suddenly says, I'm leaving, I'm out of here, I'm going to change my life, and does so on his own. 2 or 3 years later, whatever it was, someone else in that conspiracy who gets convicted, who gets charged, begins to list all the people who had once been involved, and pulls into it this guy who had once been involved and no longer was. And no, there is no category in the book that says, how do you deal with people who were once involved and no longer are? There are only general rules. But everyone understands that this is an area in which there should have been discretion. Discretion was entirely appropriate, and we have to, and a reasoned discretion means that if I have a case like Judge Pratt, I will do the same thing. I don't want to talk too long. I teach this, and so I could go on like Doug for hours and hours, but
She has an open offer to guest blog, so judges are wary about that sometimes. Don't know why.
I sent him an opinion once. We had a conversation about it, and my email was then in his blog. Why should I be wary of this?
I think I got approval.
What's wrong with this picture? If the concern is for disparity, and that was not an unreasonable concern. As I said, it actually was driven not just by northern liberals. It was driven by concerns about race discrimination. It was driven by concerns in the women's movement that certain kinds of offenses were not being dealt with seriously. But if the concern is disparity, what is always extraordinary to me is that in every other area of American law, we trust in common law rules. In negligence, when you decide slip and fall rules, you think that if I write something that is interesting and reasoned, and the Court of Appeals affirms, the judges across the country will follow. Somehow, in sentencing, which was an area that had been uniquely discretionary, we have gone over completely in the other direction, which is to believe that we don't have the means now of making judgments, of making distinctions between the Gall case and the guy who was caught red-handed, between the mule who was sitting on the stash, a huge amount of stash, but in fact was only getting $1.50 for it, between the guy who happened to be involved with lots of drugs but was clearly not making a living off of it. We can make those distinctions, and if we make those reasoned distinctions, judges across the country will follow. It was always available to the United States to have, as other industrial countries have, Western industrial countries have, appellate review of sentencing. Appellate review of sentencing even without guidelines, because what happens is that the process led to rules. I don't mind having a process in which the guidelines are alongside a reasoned common law of sentencing, where we are allowed to make distinctions for the time that the column of figures leads to a result that makes no sense, and everyone would agree. And it seems to me that that's where we ought to be, and then we should leave this discussion entirely and begin to talk about not just am I doing the same thing as the guy in the courtroom next to me, but whether either of us are doing anything that makes sense.
We'll see how these ideas fare on appeal. Continuing the alphabetical order, Judge McKee.
I think I could probably take the rest of this hour myself. There's so much I want to say, and half of it I'm sure I will leave out. But I want to start out with what I think all judges, certainly all trial judges, recognize. I'm not sure how many appellate judges do, and my court I think not that many do. And that is that sentencing is, I think, far and away the most difficult thing that a trial judge does. and I was a trial judge for about 10 or 11 years in the state court. During that time, I sat on exclusively homicide trials for about 3 years, and I chaired the Pennsylvania Sentencing Commission. And I want to emphasize there are different kinds of guidelines. We're focusing on the federal guidelines today, which I think are an abomination. Even in the so-called discretionary guise, they're still an abomination. They're just a different kind of abomination. Now it's an illusory kind of abomination. You can't quite, it's like catching smoke in a net, trying to figure out what the federal guidelines are now. But whatever they are, they don't work. But it's only one scheme of guidelines. My concern about eliminating guidelines altogether, however, and Nancy touched on this, is that one of the driving forces before guidelines was the discrepancies. And I still am not enough convinced, as much respect as I have for my colleagues, both in the courts of appeals and the district courts, I'm not convinced that the guy who is just sitting on the stash and only getting $1.50 an hour for sitting on the stash in, say, North Philly or Watts or Harlem or Bed-Stuy. Harlem's turned into a very risky neighborhood now, of course, but it's probably not a good example. But Bed-Stuy, heavily impacted urban areas where caste and class enter into it. I'm not sure that person is seen the same in most judges' eyes as the person in Scarsdale or Rye or Orange County who's doing exactly the same thing for the same amount of money and the same quantity of drugs. To that extent, I think guidelines have the potential to kind of level the playing field and take the subtle bias that is in all of us, myself included, all of us, and the subtle racism that's in all of us, to take that out of the equation, or at least minimize the impact, the potential impact of that on sentencing. Given that human frailty, if we have time, there's a wonderful personal episode that Nelson Mandela relates in his autobiography that really gets to the heart of that, I think, of how deeply all of us have this bias within us. Given that, I think the principle of guidelines makes sense, but what we've done with that principle really is, and I hope I don't use the word too often, is an abomination. Sentences, criminal sentences are very, and incarceration, that's really what we're talking about, are very, very good at punishment and incapacitation. It works to punish, it works to incapacitate. That's all we know for sure that it does. And to the extent 3553A, the federal guideline, the federal statute that talks about these various sentencing factors, that sounds really nice. To the extent that that tries to capture these other considerations for sentencing, I think it's kind of a rationalization for the real purpose, which is deterrence, not deterrence, incapacitation and punishment. I don't know of any empirical study that says that 4 years for a given offense is more likely to reduce the potential impact or the potential recidivism of that defendant than 6 years, or that somehow 4 years will make that person, 6 years will make that person a better person in the future, a better citizen than 4 years, or that the exact same conduct, if given a 7-year sentence, somehow qualitatively different, is different than giving a 7-year sentence. There's assumptions built into that. And one of the 3553A factors talks about the need for the sentence. I don't know what that means, the need for the sentence. And I don't know of any empirical studies that establish the need for the sentence, other than punishing and incapacitating. And for those things, it seems to make perfect sense. Part of the problem, I think a big part of the problem, is that the vast majority of judges, both on the courts of appeals and on the district courts, have never sentenced outside of the federal sentencing regime. Many of my colleagues have never imposed a sentence in their life. And I can't condemn too broadly with that brush, because one of my colleagues, who I almost always agree with on sentencing issues, came out of a big firm. She wasn't a trial judge before, and yet we always seem to agree on sentencing issues. So that's not necessarily a fault that precludes getting to what I would call the right result. But until you've had to sentence someone, it's very, very difficult to understand the dynamics and the pressures in this jargon that we're into now, or the court is into, the Supreme Court, between sentencing elements and sentencing factors or elements and factors, which is like not only how many angels can dance on the head of the pin, it's more like what is the angular momentum of the angels as they twirl around on the head of the pin. It's a ridiculous discussion. In one case, the court says we need to move away from that, and then a few years later, they're using the distinction, which they say is elusive, between sentencing factors and elements to justify the result and whether or not there's a Sixth Amendment violation. I think if more judges actually had the experience of sentencing people outside of the federal regime, as Nancy says, maybe they could think. And my colleagues, I don't exclude from that, certainly in my court. And as I was thinking about that last night, it reminded me, and I did some research. I used to think that this was just a kind of a story, but I went on the Great Google, and the Great Google confirms that this is actually true. In Thailand, the way elephant trainers train elephants so they can control them, because how do you control a full-grown adult elephant? How do you keep it someplace? Because it can go through anything you can tie it to. When the elephant is a small baby and hasn't fully matured and is not very strong, it's chained to a post that's driven in the ground. And it's driven very firmly, it's chained to a tree, and the elephant can't break free of its bonds. The elephant is left chained to that tree or that post, and it can't break through, and after a while it stops struggling. When the elephant is a full-grown adult and could easily take that tree out and certainly take the post out, it doesn't even try anymore because it's been so conditioned to think that it can't break free, it doesn't try to break free. That's where we are with the guidelines. The guidelines are chaining the judges on the district court and the courts of appeals to that damn tree of the grid, and we think we can't break free. We write sentences because in our circuit we don't have the presumption of reasonableness, we say, if you sentence within the guidelines. I was just reviewing a circulating draft last night. It starts out about how there's no presumption of reasonableness for a guideline sentence. And the rest of the 30-page opinion talks about the expertise of the Sentencing Commission and the whole thing about how good guideline sentences are. Any district court judge reading that is going to think, if I give a guideline sentence, I'm not going to be appealed. And if I go outside the guidelines, particularly if I go underneath the guidelines, the good chance I'm going to be reversed. And I have not seen any studies yet, but I'm not surprised to hear what Doug said, that a sentence, if we're going to get to this point, a sentence underneath the guidelines will probably be deemed unreasonable. A sentence above the guidelines that appeals to the pejorative streak in the justice system will be more likely to be deemed reasonable. And I don't want to say too much. I want to try to leave some time to respond. The Watts case, I was initially shocked by Watts, the case that basically says you can sentence considering acquitted conduct. Maybe it's because I've been either on the court too long, or too many of my colleagues are appointed by judges other than Democrats. But the more I think about it, the less trouble I have with it. It's a double jeopardy case. It's not a Sixth Amendment case. And it's beginning to make sense to me, and I'm getting very worried about that. But I can now make sense of it. The problem becomes, in the real world, judges consider a lot of things when they impose a sentence. And those things are way beyond the conduct that is endemic in or necessary to the finding of guilt that's been proven beyond a reasonable doubt. How do you decide when those things have to be proven beyond a reasonable doubt and when the judge can simply consider that fact once the fact is proven to the judge's satisfaction? And one example of this, I'll only give this example and stop because it shows how difficult the guidelines are to capture anything. When I was a state court judge, I'll never forget this case. It was a guy who was a crack addict, had been a crack addict for 15 years. And he was caught up in a part of a conspiracy, and he was caught with not a huge quantity of powder cocaine, but a big chunk of it, like half a kilo. During the court, and I can't remember what the state guidelines called for, but it was a substantial hit, at least 5 years. And we had indeterminate sentencing, so it would have been 5 to 10 years. During the course of the sentencing proceeding, he brought in his next-door neighbor from the projects, who was this retired lady living on welfare. She testified she was incapacitated, couldn't get to the store. She testified about how the only way she had to get groceries was to give Rashid grocery money. Rashid would go to the store, bring her back her groceries. And they asked her how many times she'd done that, and she said she couldn't keep track. It had been 5 or 6 years. And I asked her how her eyesight was. My eyesight is fine. Do you count your change? Of course, I always count my change, not because I don't trust Rashid, but because I always count my change. I count my change when I get to the bank. Can you ever remember a time when Rashid did not give you the receipt for the groceries and the change, and they didn't match? She said, no, Rashid would give me my groceries, I'd check the receipt, I'd always get my change back. Now, to me, that tells me this guy is a crack addict, but he thinks enough of trying to help out this woman next door that he can bring back her change and not rip her off. This is not a guy who deserves 1 day in prison. He deserves some inpatient treatment. It was a way out of the guidelines sentence, but I was able to doctor the record enough and do enough CYAing on the record that it wasn't even, it wasn't appealed. My guess is had it been appealed, it would have been a 50-50 crapshoot as to whether or not that sentence was reversed. Guidelines can't capture that kind of individual consideration. I think what Nancy is saying, thoughtful approaches to sentencing can capture it. Under the federal guidelines, that would have been somebody involved in X quantity of drugs. You'd have brought out information about his prior history dealing crack, because he had dealt crack, and he'd have been off the charts. He would have gotten an incapacitated sentence. He was in his mid-20s. He probably would have gotten out when he was in his late 50s. And it would have been an incredible, one more human tragedy that we throw into the grist of what we call our justice system. And I don't know how you get a handle on that when we're looking at things in terms of elements and sentencing factors, which I'll kind of back into and explain if I have time. But I think what's driving a lot of this insanity is the distinction between what is an element and what is a sentencing factor. That particular sentencing factor, the fact that he was not ripping off his next-door neighbor, is something that I wouldn't necessarily want to be subjected to proof by trial, because it would never come out in a trial. And I think that's what the court is trying to do now. How do we allow judges enough information to find out about the individual defendant and not require the burden of proof to be beyond a reasonable doubt to a jury or conduct they're admitting to, and give the judge enough information to impose an intelligent sentence? The problem is it's all being done within the confines and construct of these damn guidelines, which, again, we say are discretionary, and they're really not discretionary.
Judge Sutton?
Well, first of all, I want to thank ACS for inviting me to this terrific panel and participating. I had no experience with guideline sentencing, anything. Didn't take it in law school. I don't think it was offered in law school. But I've become very interested in it, and maybe two reasons. One, I'm from Columbus, Ohio, the home of Professor Berman. We used to be known for Ohio State football, and now at cocktail parties, the grocery store, coffee house is all we talk about is sentencing.
That's because you can't beat Florida.
And the damn guidelines, right. And yeah, no, you didn't have to rub that in.
We'll get to the Thai restaurants now after Judge McKee's comments, right?
But the other reason I've really become interested in it is I'm very uncomfortable with my job as a Court of Appeals judge and reviewing these sentences and trying to figure out a coherent way to do it. And we're really in an era of a common law of sentencing. I guess we have Booker to thank for that. And I find a lot of it really quite incoherent. I just can't quite figure out what the right way to deal with it is. I probably disagree a little bit with the panelists on this point. I see sentencing as about two truths that are completely incompatible. On the one hand, you have the vision of sentencing, which I think everyone in this panel shares, which is, we have these district court judges. They go through this difficult confirmation process. They're nominated by a president. At the end of that, we ought to trust them to make decisions like sentencing. They eyeball the defendants. They have a lot of experience with other defendants, these types of crimes. And when a district court judge looks at a sentence or looks at an individual, then looks at the guideline sentence and decides, okay, that range of 100 to 120 months is inappropriate here, doesn't make sense for this individual. Courts of appeals, the public, the commission, everybody ought to have a lot of trust in that district court judge's decision. And so that strikes me as one truth that I think everyone agrees with to some extent, and probably most everyone agrees with completely. But I do see another truth out there, which I find, I don't know that I call it equally important, but it seems pretty close to that level of importance, is that there really ought to be some consistency, lack of disparity between and among sentences within district courts, within courts of appeals, between courts of appeals, in other words, nationwide. I mean, if we're going to say, having a gun with a crime, having a certain number of drugs means that should be treated somewhat similarly across circuits. That strikes me as a truth, a very valuable goal. Now, that you can't do both of those things. You can't say to district court judges, you're allowed to eyeball these people, talk to them, hear their allocution, and do X one day, and then have another district court judge went through the same confirmation process, look at someone who on paper and everything else looks exactly the same and have a really significant disparity. I'll try to make this point concretely. I talk about some cases I have pending in court. I mean, it's really a bunch of cases our court's dealing with. I think most courts of appeals have this problem. These child porn cases where I think Judge Gertner may have referred to this, where it's the downloading of child porn. It's obviously a terrible problem. Congress thinks it's a terrible problem. The guidelines have been ratcheted up and up and up. to deal with this problem, and you'll get some first-time offenders, often dramatically older. I mean, 40, 60-year-old people, never done anything wrong, really honorable lives except for this serious problem. And you'll have, let's say, I'm making these numbers up, but a guidelines range of 100 to, let's say, 120 months, just to make it easy to follow. And we're getting these sentences appealed, most of them by the government, because most of them are variances downward. And they're just all over the map. I mean, there are some people that are saying these are, 1-day, 2-day sentences. Some that are saying it's a 50-month sentence. Every now and then you'll have someone outraged going above. But in this particular problem, it tends to be a downward tendency. And I don't know the answer to that one. I mean, I feel like I know one answer. If it's really an extreme variance, I'm going to look very carefully. I'm going to really expect. I guess this suggests I think proportionality review is somewhat relevant. If I see a variance down to 1 day and the recommendation's 100 months, I'm going to ask myself, there really ought to be a good explanation for that kind of extreme variance, because that seems to me to be the most extreme consistency problem you have out there. But I don't really know how to deal with that issue, this tension between individualized sentencing, discretion, almost complete discretion of district court judges, and finding out some way to have some consistency. I'm not, as a Court of Appeals judge, I'm really not interested in policing these things. I mean, the old regime looked pretty good. As I understand it, the Court of Appeals didn't do anything. That would make my life a lot easier, and it was completely coherent, right? You do nothing. That's coherent.
And consistent, too, right? Yeah.
Totally consistent. Well, the Court of Appeals were consistent, but, the sentencing wasn't. So and then I'll talk, this case that that came out the other day illustrates one other point that I might be in a little disagreement with some of the panelists about, is the role of the guidelines, how good and bad they are. This fellow, sex predator, this was not downloading child porn, this was engaging in the act. It was a really horrendous crime. So he deservedly had a range in the 10-year range. Now, he'd been a repeat offender. He'd done it once before. That jacked him up with this new guideline to roughly 20 years or so. And the district court judge was appalled, quite understandably, and sent him to the statutory maximum, 60 years. This is a 36-year-old fellow, so that's, and her point was, you've failed once before, you've done it once again already. You've shown we can't completely trust you, although there's been a 10-year gap, at least in convictions. And one more offense is one more offense too many. She heard testimony from the victims, their family. You can understand how someone could react to that. So she wanted to put him out of commission, at least when it comes to that type of problem. Now, in reversing that, which is what the Pointer decision does, the guidelines had a big impact on that. I mean, the point, I understand completely the problem with all the judges gravitating towards the numbers and the formula of the guidelines. I do think that's a serious problem. I think it underestimates a little bit the ego of most judges. Who's going to tell me how to sentence somebody? I will say it surprises me a little bit that anyone thinks judges are that likely to follow someone else's advice. I haven't seen that in 4 years. But the point is, the guidelines, you got to, whatever the rule is, it's got to be the same rule going up and the same rule going down. And in that case, the guidelines were helpful to this defendant in getting him resentenced. So I guess that's worth considering. The other thing I'd love to, I know most people think, perhaps correctly, I don't know, that the Commission isn't doing exactly what the Supreme Court and other courts think it's doing, which is to say, trying to solve this consistency problem by doing studies to figure out how people are sentenced and getting data from all kinds of sources.
That there are, each justice, and you can sort of, and I have, sort of dig into their psyche and notice in their opinions, in their work, a range of different competing principles. And in some senses may reflect back on what Judge Sutton's saying about the sort of incompatibility of some of the broader values we have in mind here. And I think particularly Justices Scalia and Thomas have emphasized the adversarial virtues of the framers' vision of trial by jury and traditional trial procedures. But that's something that some of the pragmatists on the court think makes the perfect the enemy of the good. And in fact, that's a line that Justice Breyer himself used in defending the guidelines. And so my instinct is, and again, this is academic speculation more than insider knowledge, that the court couldn't come up with a majority to either overturn a presumption of reasonableness for within guideline sentences or mandate that. And so the nice way to sort of split the difference would be to say, well, if you want to do it, it's okay, but if you don't want to do it, we're not going to say that was wrong either.
Well, this is what's so goofy about this whole area. What's really going on? The question is whether the Booker constitutional ruling precludes the implementation of the Booker remedial opinion in this way. And I think they ultimately said, we can't say the Sixth Amendment prohibits this, and so it's a common law of sentencing. You're right, it sacrifices consistency that they didn't set up one rule, but I'm kind of glad they didn't. I think they said, this is not, the presumption doesn't really, I got to tell you, you find me one case where it made a difference, I'd be really intrigued to see if that's so. And I think they probably said, why should we police this issue? It's not really affecting things.
Yeah, no, I think that the statistics are that the presumption does make a difference. That the presumption is making a difference in terms of what the rate of reversal is, and the presumption is making a difference to the district courts in terms of how consistent they are or not consistent with the guidelines. But I mean, if we can talk for a moment, the child porn cases are difficult cases all across the country. Now, putting aside the predator cases, but the downloading cases. And the question that I keep on wanting someone to answer is, and that's why I sort of talk about what are the real decisions versus the real discussions versus disparity. I want to know how many of the guys that are doing this actually touch kids. I want to know whether the internet, whether computers have created a market that never existed before. Whether the guys that are doing the downloading are not the guys that would have gone to the corner and gotten the book, and certainly not the guys that would have gotten the video, or whether they really are the same constituency. And what's the relationship between doing that, and actually becoming a predator? Instead, I have formulas. And I might add that in my court as well, these are the formulas that are actually the most difficult one. They tend to be formulas that are then applied to older men who have clean records, a family that comes in and who sort of says, I'll never do it again, and you believe them. Maybe we're wrong to believe them. So what do you do about these cases? Well, the one thing it seems to me that you can't do, and free at last notwithstanding, is you can't say, gee, I think child pornography is fabulous. I just don't agree. I mean, it's the analogy.
That one's going to get quoted out of context, right?
You'll never be on the circuit now.
Right.
But I mean, it's the analogy of one of the things that people were concerned about during the pre-guidelines period, where the judges will say, well, I don't think marijuana deserves X, and someone else will say, I think it deserves very long term. That's the kind of thinking that says, I am making a policy judgment across the board. I think that what the court is pushing us to do, which is not a bad thing, is to say, I don't think it applies to this case, because that is quintessentially legal thinking. General rule doesn't apply in this particular case, and here's why. And it's the here's why that I want to find out about. I want to understand why these guidelines have made all of us uncomfortable. And is it because they are not taking into account something that we think they should? Are they inconsistent with studies? That's the discussion, as opposed to guidelines yes or guidelines no discussion.
I think that sort of oversimplifies things. I don't think you can separate policy from individual cases. I mean, I don't think that somehow when a district judge, or this is one of the other cases that's going to be in the Supreme Court. In that case, that was an interesting case, a Fourth Circuit case. And the district judge gave a below-guideline sentence because he said that the way the guidelines treat crack and powder cocaine is completely irrational, and which many other judges have said. In fact, the Commission has now said it. And I don't know of actually any person that takes the contrary position. So the judge basically on a policy said, look, I don't think that it's fair to treat crack this way, and I'm going to make an accommodation. And the Fourth Circuit reversed him. And we'll see what the Supreme Court says about that. But see, the guidelines, I think sometimes the guidelines are bad, not because how they apply to individual circumstances, because they're just bad, okay? And no, it's maybe not good to have a judge sort of substituting his own views. And I agree, under my sort of view of the way sentencing should work, you're going to have not everybody getting the same sentence, because judges are different. But it seems to me that that's better than huge numbers, way more, getting an excessive sentence. Because the way it seems to me is the issue of criminal justice and sentencing is so politicized, and has been for the last 30 years, ever since the Model Penal Code. And you could talk about why it's that way, why it's so politicized, why it's such an emotionally fraught issue. And the Sentencing Commission is no less sensitive to those kinds of considerations than Congress is, or anybody else is. If you start mandating non-disparity, and I agree that Judge Sutton's point is, it's in the best of all worlds, it would be nice to have really, some sort of equality, assuming that every defendant, you can compare one to another, which is real hard. But it just doesn't work. And there's another thing too about this non-disparity. Discretion in the criminal process is like mercury, right? So if you take it away from the judge, then you just give it to the prosecutor. I would argue that there's more disparity under the guidelines than there was before, because the prosecutors decide the sentence. Okay? So I think that the issue that was discussed by Judge Sutton as a sort of an insoluble conflict is in fact insoluble. That you cannot do anything that's going to get everybody the same sentence, that isn't going to have so many worse side effects. So you basically have to just acknowledge that and say it's better that judges have discretion and are allowed to exercise it, and if they do something really ridiculous, there should be some kind of appellate review, and maybe light review, but I know it when I see it, something like that. And they should be, judges can be, reversed in those situations. But otherwise, I think this emphasis on uniformity or non-disparity gets us into way more problems, than it solves.
I think if we had that system, the guidelines would come back in one form or
I agree.
another, because there'd be so much discretion that appeared to, and if not, in fact, was based upon caste, where the person lived, what the person looked like, that there'd be an outcry, I think a positive outcry, to do something about what appeared to be disparate treatment based upon.
But I also think we can do better. I mean, I don't mean to say, you're not about to sentence someone and say, gee, I don't think marijuana is significant, therefore I'm going to give you probation, I don't care what the guidelines say. At the very least, we've developed a culture now where you have to say, I know there are these general rules out there, I know there are these guidelines, let me describe why I disagree with them, and here's my principled basis for disagreeing, or why I don't think that they apply in this particular case. I do think that the court is going to deal with the first, my principled basis for disagreeing with the policy, and basically say you can't do that. The genie is out of the bottle. I don't think that, that will only mean I will have more, I like to describe them as OI footnotes. They have OI footnotes in Ohio, but the OI footnote is the First Circuit requires me to do this, the Commission requires me to do this, so I'll have to do it. Oh, is this ridiculous? But I don't think I think that the only way to address this will be to individualize. That really is what is arguably our unique contribution to the system, is our ability to individualize. And I think that we can do that in the cases that need be. And when you think about what's come out of this discussion, there is a principal distinction between guys who abandon conspiracies and guys who don't. There are principal distinctions between people who make a living on drugs and those who don't. And the Commission may not have recognized those principles, but they are percolating out of the courts. And then you have a different kind of consistent system that reflects those principles.
I have a question from the audience, sort of, but I also want to, before even getting to it, broaden the conversation a little, and in some sense maybe either encourage or discourage a range of perspectives on these questions. For good or for bad, I think at the state level, there has been a movement past the sort of rules versus discretion, and I encourage everybody to appreciate how much this is a conversation about the federal sentencing system with federal judges with inevitably distinctive federal perspectives. At the state level, we are seeing, in a variety of ways, mostly driven by overflowing prison populations, a movement past rules versus discretion, and a movement toward let's figure out what works, and particularly what works to reduce recidivism. And whether it's on the West Coast, Colorado, California, that have sort of nascent efforts to deal with these issues. New York has a new commission. New Jersey has a new commission. Coast to coast, north, south, east, and west. The states don't have the luxury of time to debate these topics. They have to get the folks in and out of the system. And that's itself something that's particularly interesting to think about, especially as we code questions like federalism or the relationship between the federal government and state governments. One of the things that, from my perspective, is so interesting as someone attentive to the criminal justice system, and not that I want to put these folks out of a job or at least out of the lecture circuit talking about these issues, but it strikes me that a truly courageous and path-breaking approach to some of these issues might be to resolve this tension by simply saying we don't need a federal criminal justice system anymore. That with the exception of certain truly interstate crimes or maybe international crimes, the extent to which we actually need judges, federal judges, sentencing essentially local crimes, whether they're drug local crimes, whether they're child porn's a funny one because that's interstate in a way.
I suddenly feel like I'm in a Federalist
Well,
Society.
exactly. Never let it be.
And I just thought about did I drift asleep? Or
Never let it be said I don't endeavor to incorporate all perspectives, but again, partially it's because the federalism principles, though they may rankle folks in the American Constitution Society when applied in certain contexts, might be the path to a new direction on a lot of these questions. And I do think fundamentally, and this is what's interesting, one of the reasons I think fundamentally we've not had a congressional backlash to Booker, and I actually credit a fellow named Joe Kennedy at the University of North Carolina for helping me sort of think about this, is the war on drugs, the war on crime, is necessarily diminished when we're worried about, candidly, the war in Iraq and the war on terrorism, and when the federal government is doing things that are uniquely federal. The extent to which the Sensenbrenners and the others of the world have even the time to obsess over these local matters is diminished, and so they leave the judges alone. And the reality is, across every extreme, the system is never as broke as the people working the system might think it is. And so, good, bad, or indifferent, we get a world in which not necessarily getting folks to change the guidelines, or but just change their concern with federal involvement, may be one of the mechanisms that put this on a different path. The last question here.
Before you say that, so you don't get away with it, I don't want to leave people with the impression that if we leave the problem to the jurisdictions such as Florida, Alabama, Mississippi, Texas, that somehow we're promoting the cause of justice.
Fair enough.
Then we have to develop Eighth Amendment proportionality
Like
review.
We've got to get the Eighth Amendment.
We
politics.
got to get the Eighth Amendment.
Like politics, all sentencing is local, and a good example of sentencing being local, especially when we're here in Washington, D.C., is the Scooter Libby commutation, which I mentioned at the outset. What's wonderful, what's important to reflect on, what I actually had a chance to speak to in an interesting setting where Joe Wilson sort of commanded the attention rather than clemency and sentencing policy did. But ultimately, the president exercised discretion, indisputably authorized discretion, non-reviewable discretion, to individualize the sentence that I, Louis Scooter Libby, received. And what's fascinating, in some sense, is how much the president's decision, divorced from probably any even awareness, let alone distinct knowledge of how the guidelines worked, in some sense reflected the very principles that Nancy Gertner is encouraging to be incorporated into the federal sentencing system. There wasn't a lot of talk about, well, what do the guidelines require, and what are the point system, and gee, this was the bottom of the range, so how could it be excessive? Which, of course, is how the Supreme Court looked at these issues when the guy's name was Victor Rita rather than Scooter Libby. Very similar case worth looking at. But said instead, hey, for someone like Scooter Libby, who'll never get a chance to practice law again, who has to pay a significant fine, who has to serve probation, that's a pretty harsh sentence and a pretty hard fall from the position he was before he committed this crime, and I think that's sufficient and not greater than necessary. He didn't quite say it that way, but us sentencing nerds think of it in those terms, in light of what I believe are proper sentencing policies. And needless to say, the defense bar and others are seeking to leverage that arguably very sensible, individualized sentencing determination to benefit their clients. And I guess the sign-out question would be, do you think, or I guess maybe are you receiving the so-called Libby motions which are saying, hey, my guy's just like Libby, do the very equal justice that Judge Sutton is so concerned about. Don't let only the Scooter Libbys of the world get a break. Give my guy a break too, judges. And do you think at the broader level that moment of intriguing, though obviously politicized clarity to individualized sentencing could have a ripple effect through the work of the federal courts going forward?
I just see it as one more example of caste operating in our justice system. I don't see it as individualized sentencing at all. I see it as one more example of privilege and accumulating these get-out-of-jail-free cards. The guidelines hopefully admit against.
I see it with the same precedential value as Bush v. Gore.
I'm going to question for the panel. I'm curious, when you account for the political realities of the Congress being there, those realities, I'm curious if this whole panel agrees that the current situation is probably the best we could ask for once you assume that over the next several years the Courts of Appeals will not be policing every little variance, but really just policing, I don't know what your words, Judge Adelman, were, but I call them extreme variances.
I know it when I see it.
Well, right. Well, I'm not about to. Someone else tried that. I'm not about to use that line. But I'm curious if the whole panel agrees that we're kind of the best we can be.
The Courts of Appeals will mess it up more. We started messing it up when the guidelines came out because the Courts of Appeals were the ones who started making these guidelines, which, if you knew what you were doing in sentencing and missed it when they came out, you could get away from the standard range. There was some flexibility for the Courts of Appeals, at least in my circuit. Trumpeted in like the bull in the China shop.
I think
and messed up.
I think that they could do something now in the Gall case. They could, and this is a funny way of saying it, but I think it actually would work. I'd love to have the same kind of review that state court judges have when they are in criminal cases and they get constitutional issues wrong. In other words, there's a reasonable, we have standards for reasonableness review. We see it in habeas. You basically give a pass to a state court judge that makes a mistake in a habeas case. It's not just that he's wrong. He has to be very, very, very wrong. And to some degree, that's, I think, what we're talking about. There may be a range of reasonable sentences. In the Gall case, candidly, I can say this was not my case. I thought that what the Court of Appeals was doing was saying, geez, I just disagree. I just would do it differently. That's not, it seems to me that's not their role. The role is, what are the range of reasonable sentences here? And there could be a given range, and are you within it? And we know how to do that with habeas. We know how to do that with administrative law. It seems to me that we could do that in sentencing. And the irony is, in fact, it makes more sense in sentencing, given how individualized sentencing is, than in constitutional habeas review or administrative law.
It'll happen with upward departures. It won't happen with downward departures.
But maybe you think I'm not.
Especially because we have a terrific lunch on the horizon. I'm supposed to tell you to join us all promptly at 1:15 for the luncheon featuring Senator Charles Schumer. Lunch is served in salons 2 and 3 of the Marriott Ballroom on the lobby level. Volunteers will help guide you in the direction. I also want to follow up Judge Sutton's question by just saying I would be confident we live in the best of all possible worlds if I knew that every single sentencing decision came before the judges on this panel. I'm sure they'd like that too. Thank you for the engagement. That was terrific. Thank you all.